does it violate the U.S. Constitution to require a baker to decorate a cake with a message celebrating gay marriage if that baker is opposed to gay marriage on religious grounds? Mikey, why don't we start with your side?
All right, you want to go? I'll go. Go ahead. Thanks. We've been waiting for this.
Yeah. Well, this is one that's in all our minds. It's a Colorado case. It's the Masterpiece Cake Shop. It's an interesting one. So there's a law in Colorado that bans discrimination in places of public accommodation. So Colorado defines that as any place of business engaged in sales to the public, wholesale or retail, and any place to eat, drink, sleep, or rest for pay, basically hotel, restaurant, store. So the interesting question would be if Masterpiece Cake Shop were instead artists who would paint paintings and never took commission work. They just painted what they felt like. Can the law force them to start taking on clients who want certain things? No, the law can't. But once they open up as a public accommodation, they have a door anyone can walk in to buy a cake, they qualify as a public accommodation. Now then they said, well, but we're really artists because we are cake artists. Now, okay, but if you go to Subway on their webpage, they describe their employees as, anyone know? Sandwich artists. Thank you, Tyler, my former constitutional law student and scholar of Subway. So yes, Subway has sandwich artists. And when I bought a cake for my 8-year-old kid at King Soopers, it said, happy birthday. Did I go up to the person behind the counter, paid minimum wage, and say, I am so touched that you wish my kid a happy birthday? No, this person isn't wishing me a happy birthday. I asked them to write happy birthday. It's several letters on a cake. So, and that's why Masterpiece Cake, as the shop, hardly disagreed. Look at the facts of the case. They did not deny that they qualify as a public accommodation. That's page 3, paragraph 7 of the Court of Appeals opinion against them. Instead, they were arguing that even though we are a public accommodation, not private artists who do what we will and don't open up to the public, they said, we get an exemption from all civil rights laws if we don't want to sell to you because, frankly, we hate you. Now, this has been covered. No, they don't hate them, of course not. So this was covered in the early civil rights cases in the 1960s, the exact same argument. Defendant who owns a restaurant contend that the Civil Rights Act, passed in 1964, violated his freedom of religion since his, quote, since his religious beliefs compel him to oppose any integration of the races. In Loving v. Virginia about interracial marriage, a judge who didn't want to marry them said, quote, Almighty God created the races white, black, yellow, Malay, and red and placed them on separate continents. But for the interference with his arrangement, there will be no cause for such marriages. The fact that he separated the races shows he did not intend for the races to mix. There is no neutral principle of law that lets Masterpiece Cake say, I don't want to sell a congratulations cake to the gay couple, but that lets, frankly, any civil rights law exist. Because if they get their exemption, there is literally nobody who can't go to court and say, I get that there's a law against discrimination, but it's all a balancing, as Theresa said. So I have deeply held beliefs, and under the First Amendment, your deeply held secular beliefs can qualify as having the same religion protection. So I want an exemption, and then everybody gets an exemption, then we don't have these laws. So if you open up for commerce, you can't discriminate. That's just the way the commerce works in America.
Well, as Mr. Moss says, this is an interesting and complicated case. The question got to whether the holding in the case violated the constitutional rights of the baker. And the answer in this type of case is it depends, because it depends on which standard gets applied. So under state law, which is where we are with this case, First Amendment rights normally no longer get strict scrutiny, which is a high standard of review requiring the government to have a compelling interest. Normally it's rational basis, and that's what the court used here. But there can be an exception to that if there's a hybrid right, meaning there's two constitutional rights involved, or if there's another constitutional right. And so what the baker is arguing is that there is a second constitutional right, which is the free speech right, the compelled speech issue. And if you want to think of a parallel, for instance, the dress designers who declined to provide dresses for the Trump family for the inauguration, they didn't want to prostitute their art for a cause they didn't believe in. or sometimes musicians have refused to license songs for a political convention where they didn't agree with the principle of the convention. So the ACLU's general position on speech is, quote, "A free society is based on the principle that each and every individual has the right to decide what art or entertainment he or she wants or does not want to receive and create." Now, obviously, Mr. Moss is arguing that because someone commissioned the art, that right goes away. And we may find out if the Supreme Court grants cert on the case. Right now we're not sure. So these are the complexities here. If the review is only rational basis, it would appear that the religious free exercise rights can't be exercised. So I want to add a further point here. If we were operating under federal law, it would be controlled by the Religious Freedom Restoration Act, which would return us to the strict scrutiny that we had before the Employment Division case I mentioned that gave us rational basis scrutiny. Many states have a Religious Freedom Restoration Act statute. Colorado's not one of them. So one of our collective decisions as a state may end up being, do we feel that religious freedom deserves protection to the extent that we should enact what lawyers call mini RFRAs in order to protect free exercise in the states? And so that's the 3-minute intertwining of my view of the constitutional doctrines here.
And if nobody objects, we'll continue this for another round since it's literally in our backyard here, this question. Scott, a quick follow-up. Under your analysis, if somebody walked into Masterpiece Bakery and was an atheist and asked the baker to make a cake and asked the baker to write on top, Jesus Christ was a fraud, would the baker be required to do that?
So this case, though, in other states, there was something close to that in Kentucky. I don't remember the exact specifics, but basically it depends on what their line of business is. If I have a website that sells T-shirts, and the way my business operates is type in the text you want, our machine spits out the T-shirt, we mail it to you, then you can't exclude a certain message if it is excluding a particular group. It would depend on whether the state's public accommodation law covers discrimination based on religion in consumer affairs, because Masterpiece Cake was about LGBTQ folks, so I'm not sure how the public accommodation law fully applies to religion. But what it gets to is that if your business is selling we print whatever, then nobody could fairly interpret that as your speech. You're not being impelled to speak. You're transcribing someone else's speech. It would be like a court reporter saying, I don't like that testimony, so I'm not going to type it. Well, no, your business that you opened up for is to type out what I say. So too with the cake shop. If your business is, we will print your message on a cake, then you can do it. There are exceptions for obscenity in, I believe, the Kentucky case. But if, in contrast, your business is you just sell cakes and you don't normally write messages on them, then they can't say, you know what, I'd like you to also write on my cake, because then you're being asked to do something you don't normally sell for a living. So that's, I think, the gist of it. As I see it. Mike, if you want to.
Well, look, we've had some of these even in the military. The bottom line here, when you cut down to the bottom of the cake, right, is the problem is that the book, as many of you in this room interpret it, the book says being gay is a choice. It's a choice to join with Satan, hate the sin, love the sinner, and we cannot stand that. And if somehow this is okay, well, this invalidates the book. If there's one thing, because the book is inviolable. And even though the fact that the book also states that if you have mouthy teenagers under Leviticus, you should stone them at the city gate to death. So let's just cut to I understand the concept of lesbianism, LGBTQ. We have a situation now with a new commandant coming in to the Air Force Academy, is a brilliant woman, Brigadier General Select. She and her wife and her 2 children will soon be taking over there. And this has caused a tremendous row about, my gosh, this is a general, and what kind of example is she setting? And so when we're talking about accommodations, as I said before, you need to ask yourselves on this Tuesday evening, have people really made it? Did she really make a choice that she'd have a faster path to general by expressing her love for a woman And she didn't even realize what her sexuality was until she was well, past the don't ask, don't tell deadline. So when that kicked in, the bottom line is that really a choice to be with Satan, or is that possibly, as Lady Gaga says, that is the way that you were born? And I'm not talking about being in prison where you're gay for the stay. I'm talking about a human being the way that you are. You need to ask these questions, ladies and gentlemen. Thank you.
So a good bit of what Mr. Moss was talking about here was the question of what is speech, and whether a company can be compelled to provide speech if it's generally in the business of providing speech. Another recent case, Hands-On Originals, the owners refused to print T-shirts for the Lexington Pride Festival because doing that conflicted with their Christian values. The speech involved was fairly innocuous in some ways. It just mentioned the festival, so there weren't any obscenities or that type of thing. But they felt in good conscience they couldn't do it, and the court agreed that that would have been compelled speech, and indeed they didn't need to do it. So then we get to the obviously more difficult question: is a work of art celebrating a wedding conveying some kind of expressive message or not? And we don't really know yet because the Supreme Court hasn't taken up those cases. Obviously, I'm arguing that it is. I feel pretty strongly about all types of art as forms of expression by the artist, but I think you can easily see that there's room for healthy disagreement on this topic.
There are a number of businesses that have signs up, like the McDonald's in downtown Colorado Springs, that says we reserve the right to refuse service to any person. The question at hand is, does a business owner who has religious convictions that conflict with the request of a customer, does that business owner have the right to deny a good or a service based on their religious convictions? As it's been traditionally understood, legally, the religious convictions end when or the right to express the religious convictions end when they do appreciable harm to the person in question. Now, I know that many people would find this odious, and in this, hyper-tolerant, very entitled culture in which we live, people want to be able to demand that I will have service, whether you like it or not, you will serve me. But look, if they don't get the cake at one baker, they can get the cake at another baker. If the business owner, the photographer, the florist, the baker, the T-shirt printer has the right to refuse service, not out of malice, not out of ill will, not out of the desire to do harm to another, but simply the desire to not violate what they believe they're standing to be before their God, doesn't mean that they've denied an immutable right that a person possesses. Doesn't mean that they've withheld the right of the customer or the potential customer to go elsewhere and get the good or the service. And so I would maintain that even though sometimes it might go against what we believe, we should reserve the right of business owners to conduct their business based on their convictions.
That will be time. Thank you.